Yeah, so the rescission element, obviously the difference between Johnson, Hopcraft and Wrench is that, the tort of bribery element. Can you just explain sort of why that is, what the difference is, and obviously why it makes sense that the lenders are pushing back so much from a layman's perspective?
Yeah, from a factual point of view, it hinges on something being fully secret as opposed to half secret. And if something's found to be fully secret, then you are entitled to rescission as a remedy, as of right. And rescission is, in simple terms, unwinding an agreement, and you kind of, as if it never happened, say, what have I paid to you? What have you given me? And you offset it, which inevitably would involve consideration of the value of the car if you've still got it, how many miles on the clock, which does make it a case-by-case basis for redress, which would make mass redress or also redress a bit of a problem because you'd have to look at each individual case. But that's the main difference. Was half secret, it's at the discretion of the court whether they wish to award rescission or to award the equitable remedy, which would typically be the refund of the commission, or the return of the commission, I should say.
Yeah, and obviously there's a significant difference between what the client would receive as compensation if on a simple unfair relationship argument, and if a bribery element was introduced and rescission was done. So it makes sense why they're really taking this all the way.
Yeah, it enhances the potential value of a successful claim.
Yeah, but from a mass redress event, especially from a sort of CMC perspective or a volume law firm perspective, the actual rescission element will make the entire process a lot harder.
Yeah.
Like you say, you're then going to have to appraise every single deal on a deal-by-deal basis, how long the car was used for by the client, how many miles they did,
whether they've still got it.
Yeah. I suppose that's the state the car was handed back in. So I suppose just my opinion, from an industry's perspective, you kind of don't want that.
If you're a CMC and you're looking at mass redress, no, probably not. If you're going through the courts, then it's part and parcel of...
Yeah, so whether they're all individual basis anyway, aren't they? Yeah.
So
it's really interesting. I suppose when I was just driving in, I was just re-listening to the podcast that we did back in December, and some of the time frames that you set in that last podcast, I completely forgot about. Obviously, we discussed a lot about that, but you said, this is an expedited case with the Supreme Court, and they have moved quite quickly.
Yeah, really quickly.
And you said that obviously you would expect them to hear it maybe. Obviously, it's April 1st, 2nd and 3rd of this year. And we'd expect the judgment to probably come down before summer recess.
Yeah.
But you're saying that once that happens for a redress event, I mean, if you like it to PPI, we could be waiting years.
Yeah. My PPI experience tells me that if we were to get a decision from the Supreme Court in the summer...
Move that just slightly closer.
Which I think we will.
That's amazing.
Then I think the FCA/FOS will maintain the December 2025 review. But depending on the Supreme Court decision, and if it went in the way of the consumer, I can't see any redress scheme being up and running by the end of 2026. Maybe, but I think they will have to come up with a consultation paper. That'll require responses from both sides of the industry, and then they'll have to formulate rules. Once those rules come out, then lenders, as I say, this is predicated on the basis that the Supreme Court decision goes in favour of the consumer. Lenders will need to have time to digest those rules. There'll probably be a generous window for a lender to consider a complaint for car finance and issue a final response. I think you're talking, for my money, 2027 onwards.
Really? Yeah. For a real redress scheme to go live?
To be on foot and checks to be sent out, or...
And that's based off like what happened with PPI?
Yeah, if you look at PPI as a yardstick, the Supreme Court handed down its decision in Plevin in November 2014 and the rules which underpinned PPI redress didn't come out until March 2017. So that's a 2.5 year, or just shy of a 2.5 year lag between the FOS/FCA implementing the principles of a Supreme Court decision in relation to PPI. And let's bear in mind, PPI redress was very simple. It was what they came up with, which I think wasn't good enough, in my opinion. They set down rules which, if a lender decided to uphold a complaint, they would refund the amount of commission over 50% plus 8% interest. Well, that's a formula. I think with car finance, as you've alluded to, there's more elements than just give back the commission over 50% plus 8% interest, which is the PPI model.
Yeah.
It took them 2 years, 4 months to come up with a very straightforward redress scheme. How long is it going to take them for car finance? I'd be amazed if they did it sooner. And if we say Supreme Court decision, finger in the air, comes out July 2025, well, what's 2 years, 4 months? It's towards the end of 2027.
So what do you think the reason for that delay would be, though? Like, obviously the Supreme Court would hand down the judgment as the same as the Court of Appeal stuff had a clear like redress methodology in there. Would they not just adopt what the Supreme Court says, or an amalgamation of the Supreme Court and the Court of Appeal one and maybe a FOS decision?
I don't think it's... I hear what you're saying in theory, but the problem is they have to issue a consultation paper. So there will be a watering down.
So that'd be like the 10th consultation they've done.
Exactly. So there will be an inevitable, in my opinion, watering down of any Supreme Court decision that goes in favour of a consumer. I mean, let's go back to the PPI model. In Plevin, after the Supreme Court gave its decision, it was remitted back to Manchester County Court where it started. And the judge at County Court level, his redress was refund the commission. That was it. Dead straightforward. FOS didn't implement that as a method for upholding PPI complaints. What FOS did was say, well, what we'll do is we'll not do that. What we'll say is up to 50% commission is fine. Just refund the balance. So if your commission was 80%, your redress would be 30% plus 8% interest. Well, that's watering down what the Supreme Court did, because the Supreme Court would say, well, no, refund all the commission with interest. But FOS watered it down, and what it took was a tennis match of consultation paper, feedback, some rules. So I just can't see it being, right, Supreme Court say this, we will now implement it verbatim at complaints level. There'll be a consultation paper, and as night follows day, the lenders are going to lobby hard to have it watered down because they want to pay less redress, because they want to retain more profit that they've made by mis-selling. So I just can't see anything really happening until 22-27, and that's being optimistic. If we take the PPI time frame, 2 years, 4 months, well, what would that be? That'd be the autumn of 2027. And then they'd have 8 weeks to respond. So you could be into 2028.
I've just realised I've been turning the volume up in your headphones and not mine. Is that really loud?
It's fine.
Is that okay?
Yeah.
Okay. I was like, why does Kevin sound really quiet in my headphones? I just had to trace the wire back. Then I was like, shit, Kevin's on full volume here. Every time I go, yeah. No, that's crazy though, because I don't think anyone, the way I'm seeing the social media adverts and so on, I don't think anyone's anticipating such a lengthy decision process, considering the Supreme Court have gone, boom, this is a decision. Given everything that the FCA has been through with PPI and Plevin, and obviously the consultation periods involved in that, like you've just elaborated on, and the FCA coming out as of like January 11th last year, announcing the pause, extending the pause numerous times. Obviously, there's been Treasury Select Committee meetings, there's been consultations, as we've both done Freedom of Information Request Acts, Freedom of Information requests to the FCA to say, who are these consultations happening with, which they pretty much have said, yeah, it's all lender consultation.
Not said otherwise.
They've not said otherwise, and they've definitely not contacted either of us. Surely, just to sort of play devil's advocate, surely they're trying to get ahead of this consultation period to say, listen, guys, this is coming. What does a redress scheme look like so we can put it to bed?
I don't think they can anticipate which way it's going to go with the Supreme Court. I don't think they can get ahead of any curve.
Yeah.
Look, I'm a pessimist, and a pessimist's never disappointed. And I would love it if the FCA and the FOS had a scheme that was on foot less than the 2-year window I've given them, but I just can't see it based on what happened in Plevin.
Yeah, like you'd like to think they're working a bit smart in the background.
No,
just a what-if scenario.
In my experience and what history tells me is that the FOS react. They're not proactive, they're reactive. So,
and the FCA.
And the FCA. I mean, the investigation they did in relation to discretionary charge agreements, they should have been policed a lot sooner. They reacted to the investigation. It took them 2 years to come up with the findings, and they're all on hold. It's you could have theoretically, depending on what happens in the Supreme Court, you could have a period whereby they've investigated something in 2019. They may not start upholding complaints pursuant to that finding on a mass redress scheme until 2027, which is 8 years. Which is, it's pretty slow, isn't it?
It's crazy.
Yeah.
Well, it's also crazy that from a perspective of statute of limitations, the way I've considered Martin Lewis coming out on TV and getting people to file their complaints, I always thought, is this a way to get the clock ticking? Because the FCA have not come out. I know in the last consultation, they said, should we not have the clock ticking in regard to limitation whilst all the investigations are going on? But if you take the point that you just said about this could be 2027, 2028, surely there's going to be so many people who have filed a complaint. The lenders, one, don't need to keep the records anymore because it's well out of that window. But two, they might have filed a complaint in 2022, 2023.
If I look at it from a civil litigation point of view regarding limitation, I think you firstly need to know whether your lender has actually received a commission. And
which we know is highly likely.
It's highly likely, but you still need confirmation because they say may. They may not.
Yeah.
It's not a guarantee. The industry suggested it's highly likely, but in order for you to know whether you've got a claim, you need to know whether there's a commission actually been paid. You don't usually find that out until you've issued proceedings, usually.
So you're saying that once people have submitted a complaint, that really shouldn't be the start of the tick of the clock?
I don't think so, no. Because the consumer is taking a punt that you may have received a commission. Tell me if you have.
Yeah, they've had a car of finance, they've made a complaint or an inquiry.
Yeah. You could have a lender say, we didn't pay. A commission says may. Well, we didn't on this occasion. You have not got a claim. And you would advise that claim. You haven't got a claim. Close the file.
Well, the letters that are coming back to response complaints at the minute are we're conducting an investigation as per the FCA, and they're not giving you any information.
So in order to bring a claim, you need to know you've got the fact that's relevant to your claim. Well, it's the payment of a commission that's not disclosed. Until you get the green light on the commission being paid, I don't think limitation should start.
Yeah, no, when you put it like that, I agree.
But I'm talking from a civil litigation point of view. The FOS with their complaint scheme have their own limitation periods. I think it would be really unfair if they were to impose a limitation period that cuts out consumers because of a delay they've caused themselves by taking
ages to do a redress scheme. Yeah. Well, I think that goes on to the point is, what side are they really on? We saw the whole Rachel Reeves scenario come out in regards to the Treasury intervention. If that was not the biggest slap in the face to your average consumer, I have no idea what is. A Labour government coming out and saying, no, you have been acknowledging you have been missold, but not trying to put a massive roadblock in the way in form of intervention to say, yeah, you've been missold, but we're not going to side with you on the compensation side of things. We're more asked about the banks being destabilised, which was an absolutely shallow argument in my point once you start to strip it back.
Very strange move by the government, I have to say, on that. And I think the Supreme Court have acted quite correctly in refusing the application to intervene.
So yeah, we'll just quickly touch over the interventions, because I don't want to dwell on the whole Supreme Court stuff, because I'm conscious that it's not our position to really be commenting on it anymore.
Yeah, it's not.
But obviously there was 5 interventions.
Yeah.
And they caused a bit of a stir within the industry. Well, they definitely caused a stir for like maybe December, definitely all of January. People didn't know what the weight of them were, what the basis of the intervention was. You know, especially when the Treasury came out, I think a lot of people got very nervous, thinking, wow, the government's now getting involved in a private individual's case.
Yeah, that was the main thing. That's where it rubs up against your intuition a bit. And you think, you got let me take my client, Mr. Johnson. He has a private claim, where he's won in the Court of Appeal, and it's allowed him to seek redress. And the lenders have decided to appeal to the Supreme Court, which is entitled to do. But then your government, who
Labour government
pay taxes, Labour government who you pay taxes to, wants to get involved in your private case to help your opponent succeed. That's very unconstitutional.
Well,
as far as I'm concerned.
What you said to me on the phone when we was discussing this was that, ultimately that Labour government intervention, had it have succeeded and ultimately had Mr. Johnson failed in the Supreme Court, we're talking obviously months in advance here, but he would have been not only lost but forced to pay that money back.
Yeah, it would overturned. And the bank quite rightly would say, ultimately, we won in the fact we successfully defended your claim. You need to return that money, which would be, well, that would be right, because that's what happens on appeal. You know, I've been on both sides of an appeal, but it would be a real kick in the teeth for Mr. Johnson. Think, well, the Labour government kind of pitched in and threw its weight behind the lender. The issue with the interventions, just to explain, is it's where a third party or a party who's not involved in the appeal, so it's not Johnson, Wrench, Hopcraft or FirstRand and Close Brothers, wants to speak or give submissions, both written and oral, to the Supreme Court. The basic principle is that it needs to be something not already covered by the parties. Can't be duplicitous or irrelevant. The feeling was, what else can you say that the parties aren't already covering? That's at its heart. That's what you're saying, because you have 3 days, and these interventions cut into your time. You know, it's a precious 3 days, and you've got to get all your arguments out. And you've got to do it in a timely fashion, and there's going to be some interventions from the Lords themselves, which is how appeals work. They need to understand the case, and there's it's not like your trial where often you'll have a judge who'll just sit back and listen to the evidence and the submissions and then give a judgment. What tends to happen in an appeal is that the judges want to understand the issues, so they'll often intervene themselves and ask counsel, who's given their submissions, for a bit more clarity. What's your opinion on this, or what's your view on that? Or these interventions are cutting into that precious time, which is why they have to be not duplicitous or not irrelevant. Whereby I think the Supreme Court have got it right in the interventions they've allowed. They've allowed the FCA because they have a unique role within this area, in that they're neither claimant nor lender. They're kind of in the middle.
They're not supposed to be.
Not supposed to be. And then you've got the I can't remember. There's a Brokers Association.
Yeah, like the
National Dealers Association. I understand why they've been allowed.
Franchise.
Because the lenders are the defendants, appellants in this case, and the dealers aren't represented per se. So, okay, the Supreme Court wants to hear them.
Yeah, I did think it was a bit of a weird one with the FCA. I mean, I've got my own opinion of the FCA, not to start going into sort of conspiracy theories, but the whole Franchise Dealers Association, well, the stuff that we've uncovered and that you've sort of seen is that, you know, the dealers, they're of course not going to want. I mean, from a lender's perspective, I kind of say, yeah, they don't want to pay back all of that money. They don't want to pay the money back that they incentivize, but they're still going to lend money to brokers, car dealers who need that finance available, because obviously it's a massive easy win or easy access to the client to buy a car. So they've not got a business without obviously this finance model. But also the dealers are earning so much more money from the finance agreement or from the finance going in place than the actual cars, that I wondered with their intervention if they're representing the dealers, surely they're going to be 100% biased to basically deploying all of the arguments that Rachel Reeves deployed, all of the stuff about destabilizing the economy, the fact that it's going to make lending.
Oh yeah,
so
definitely
they're not going to be impartial.
No, the absolute 100%. They are siding with the lenders. They're
They're
absolutely.
in cahoots,
But what they will say is that we wanted to explain to the Supreme Court, and I'm guessing here, but they will want to explain the process, and they'll want to say that it's not what we're saying it's in breach of. So they'll just want to
have their moment.
Yeah. I can understand why they've been allowed to intervene, for sure. I mean, I mightn't like it because obviously they're against what we want to say, but I understand the basis of it, and the Supreme Court want to be as thorough as possible, and they've said no to the Treasury, which I think is correct, and they said yes to the FCA and the Dealer Association, which obviously I don't want the time to be taken away from our arguments. We want as much time as the Supreme Court will allow, but there has to be due process, and I think it's right. The Supreme Court have said okay to the FCA and to the Dealer Association, we'll hear from you, and they'll just take on board. They said because when they give their judgment, there can be no suggestion that all the relevant parties' arguments weren't considered. It will be a holistic, fulsome. It's going to be the law for who knows how long. They have to get it right, and they have to have conducted a thorough assessment of all the issues, all the submissions from all the relevant parties, and I think they are doing that. We just don't want it to cut too much into our time.
Well, I suppose as well, like if they didn't do that, they would be leaving it all open to, well, the FCA should have been allowed. It wasn't done properly.
Yeah.
So just for everyone listening who's not up to date, obviously there was 5 attempts, 2 of which have been allowed, like you say, the National Franchise Dealers Association, the FCA, but obviously the Treasury failed, the Finance and Leasing Association failed, Consumer Voice failed.
Yeah.
Given your experience with the Supreme Court, was 5 interventions even possible?
Short answer, not with 3 days. I wondered whether if the interventions were allowed, there'd need to be a 4th day.
Yeah.
But I didn't see the 5 being allowed, just purely from a time constraint point of view. So I've only had one other Supreme Court case, and there was no interventions then. This was relatively new to me, although I understood the concept. I didn't think all 5 would be allowed. Yeah. But I couldn't. I had a feeling the FCA would be allowed, but for the rest of them, I had no idea whether they'd be allowed or not. But I did think, as I say, every intervener would need at least half an hour. You've got 5.
Yeah.
It's taken up almost half a day.
Well, you say at least half an hour. Like what can you actually get done from a material, like from sort of your argument having any form of like gravitas or anything like that? What can you get done within half an hour?
It's a good rhetorical question.
Yeah, because
it is a good rhetorical
I know
question.
from just the small track claims that we're doing, it takes the judge half an hour just to flick through the bundles, and once you point into the specific parts and so on, like half an hour.
Well, these judges will be white hot. They'll be very on it, if you like. And
but there's going to be a significant amount of documentation that they'll have to be probably pointed to, and I don't know, maybe pull out this document, pull out that document, Lord.
I don't know. I just think they'll have to be very punchy with their submissions and not go too fast. Yeah. But that's their problem. They're intervening, and they've got there's the short window. and they've got to go for it.
When will you think that they will be allowed to do their actual interventions? Do you think it'll be in day 1, day 2, day 3?
I don't know, actually. It's a good question. The timetable hasn't been set out yet, but I don't know. Intuition tells me that the Supreme Court want to hear, obviously, from the appellants first, and then they may want to hear from the respondents, and then deal with the interventions afterwards. But I don't know. We'll find out soon enough, and it will all play out from the first. But I don't know, actually. It's a good question.
Yeah, because I was trying to think, like, when is it almost like a footnote, like, here, there's the FCA's time now, let's just all have our eat our sandwiches whilst they're doing that? Or is it
couldn't possibly comment. I think it might be that
go for
just take a step back, and it's the appellant's case. They're bringing the appeal. They go first.
Yeah, you have to talk about the facts specific to that case.
And then the respondent should be entitled to respond. And then usually what happens if you have no interveners, the appellant gets a reply. So I don't know when it'll, that's what happened in Potter. That's what tends to happen in most appeals. Appellant goes first, the respondent responds to it, and then the appellant has a short reply. So it's whether they come after the appellant's reply right at the end, or before the reply, and after the respondent's case. But they may raise something of use to the Supreme Court. You don't know. That's why they're being allowed in. And I just think it's right and proper that the Supreme Court's judgment takes everything into account. Leave no stone unturned, as the phrase goes. And like I say, then there can be no cry arson from the industry that everything wasn't considered. It's like, well, look, everyone who needs to speak got to speak.
Yeah.
That's it,
Yeah, they're not leaving any opportunity for someone to literally whinge if it doesn't go their way. So, well, we heard from everyone.
Yeah,
well, I mean,
and they can whinge all they want.
Well, I mean, as well, that I just don't see it, obviously, just moving slightly on here, is that we're at about £2 billion that's publicly been set aside for car finance compensation now.
Yeah.
Lloyd's came out, it was all earnings season pretty much like this February. Lloyd's have obviously come out and been the biggest. They've put over like 1.15 billion to the side in their accounts, acknowledging it for motor finance claims. Santander, Close Brothers, Barclays, we are at 2 billion quid. Surely that is
I'll be 36 billion short.
Yeah, I know, exactly. Yeah, we're massive. I mean, we worked out, if you worked off the
Moody's
the money that's been allocated against the amount of agreements that the FCA have said, it was about 54 quid an agreement in compensation, which obviously is just laughable.
Loose change.
Yeah. But surely from their perspective, if you were so confident on what's going on in the Supreme Court, and obviously your appeal and what you're going to say and your interventions and so on and a million other things, you wouldn't be making provisions industry-wide of 2 billion quid. It's not a small amount of money.
No, you probably
just
know
speculating.
More. No, you may know more about this than I do, but and jump in. My understanding is the reason why they make these declarations is for the benefit of shareholders, isn't it? And
yeah.
It's a bit of a look.
We're doing something about it. We've accounted for it in our share price. Yeah.
This bad thing may happen where the decision goes against us. It may affect our share price.
Yeah.
We are putting a provision in that to buttress it or to guard against it. But there is obviously a disconnect because Moody's have said it's 38 billion.
Yeah. So where's that?
So where's the other 36 billion?
Yeah. There's not going to be 36 billion of legal costs.
When I see these announcements, it's curious because there's part of me that thinks, oh, well, you see the writings on the wall then. But then they may be just being prudent and saying, well, we are just putting it aside.
Yeah.
If the Supreme Court find in our favour, we'll just put it back into the main
we'll just
pot.
Move it.
But I don't really read too much into it, to be honest, because it's all numbers in the air, really.
Yeah.
They can put it aside, they can put it in a drawer, they can put it in a car boot. Who knows where they put it, but it's still in their bank account
Yeah.
and not in our client's bank account, which from our point of view where it should be, and they've had that money for a long time.
Yeah, well, it's almost lip service at the minute, isn't it? I
Possibly,
mean, from what I've read into it and speaking to some of the bank analysts that I share information with, is that they have to make this provision to mitigate the share price risk. Obviously, it can't be valued at a tenner, knowing that you might have this massive liability. They'll bring it down to like a £5 or something like that. So they've obviously had to put this into their accounts to show that actually the share price today is an accurate reflection of the state of the business and all its liabilities. Yeah. But one of the things that they do have to do is obviously get signed off by an independent auditing company. And they can't just put they can't put it as like, oh yeah, we're going to put £1 billion around. And then the auditors go, yeah, that's fine, just put it off. If they've not presented a good enough argument to justify that provision. So I do think this is the lowest amount they could have ever published this first time around and still get signed off as a PLC. Right. So it's interesting. I mean, it's at 2 billion now. I don't know, you'll know better than I, but I think I saw the way or the roadmap of redress for PPI. I think it started out something like £1 billion, and then every single year it seemed to like creep up by like £1 billion or 2 billion, and then I think 2016, 2017 it went from like 10 billion to 25 billion or something like that. That's what it just went nuts. So I just think if you was to follow that roadmap, you know, we're at 2 billion now. Next quarter, let's see what else they put aside, and obviously Q3 this year. Yeah, the Supreme Court judgment should be out by then.
Yeah, when you put it like that, I get it. Yeah, it does make sense, but it changes all the time. You know.
Wait, going back to what you said about the whole rescission argument. You know, if that got awarded, what genuinely like
rip that up and
it's actually baffling as to okay, how would you even calculate the redress from then? Yeah. You know, on an industry-wide scale.
It's like bingo.
It's literally,
it's like what number comes out, I don't know.
Literally. I think I just want to go in. I want to like stop talking about the specifics now, but I want to talk about like the wider things that are going on in the market that people are talking about now. Obviously, Supreme Court's happening in April, but the introduction of the FOS fees. I mean, let's just get a bit busy on that because with the Treasury intervention, that was the first kick in the teeth to go, hang on a minute, what side are the regulators on? What side's the government on? Yeah. This is a Labour government. They're supposed to represent the working man, the blue-collar workers. You know, there's
a lot of promises made pre-election.
Exactly, yeah. A lot of promises made.
Where were they? Yeah.
But what seems to have happened with the introduction of the FOS fees seems to be 100% at the consumer's detriment and just yet another roadblock to what is obviously the impending avalanche of financial claims across the industry, not just car finance.
Absolute disgrace. It's not a roadblock. They've blown the road up, as far as I'm concerned. Just to explain to those listening, the FOS want to introduce a fee for any consumer representative bringing a complaint on behalf of a consumer. The way it used to work, and it currently works at the moment, is where you could bring a complaint for free through a consumer representative, and if that complaint was upheld, there was a levy on the lender or the respondent, and I think that used £650. I might be wrong on that. What the FCA and the FOS were looking to introduce and are going to introduce from the 1st of April is that levy also applying to a consumer representative. So if a consumer representative brings a successful complaint on behalf of a consumer from the 1st of April onwards, they have to pay £250 up front to bring the complaint, and then if the complaint's upheld, they get a refund. I think it's £175, thereby resulting in the cost of bringing the complaint to be £75. That, to me, is insane. Now, the FCA and FOS asked for various consumer representatives in the summer to provide feedback, which I did, and I'm happy for you to, publish that because that sets out more detail. Yeah. But the language of the questions was so this is a done deal.
Yeah.
Like, do you think £250 a fair fee? And my answers were no fee. What are you playing at, kind of thing? Because if you think about it, what they're saying is, but if a consumer wants to bring a complaint, they can do it for free. Well, one, the consumer doesn't have the time. Two, they don't have the inclination. Three, they don't have the expertise. That's why they want a consumer representative to do it for them. We are not talking about a refund of stale milk back to Sainsbury's. This is complex law, which the Supreme Court are tackling, and the Court of Appeal had to tackle, and it's complex areas of law. And the FOS is saying, but if you do it yourself, you don't have to pay a fee. And we've said this on previous podcasts, you can wash your car yourself.
Yeah.
But if you choose to pay a car wash, no one's bothered. No one goes, whoa, what are you doing? Get out your car. Here's a sponge. You can do this for free. It's like, well, I'm happy to pay the whatever. And it's the same applies to a financial mis-selling complaint. If a consumer wants to do a deal with a consumer representative, a CMC or a solicitor, and say, look, if you work for me on a no fee basis, I'll pay you the percentage that the government has allowed. Why is anyone bothered? That's a private transaction between two parties. Doesn't cost the lender any more money. If they pay out £1,000 and say, for argument's sake, the fee's 25%, well, the client gets £750. Consumer representative gets £250. The lender still only pays out £1,000.
Yeah.
No extra cost to him. So what's the problem? It's absolute. It's baffling that they've brought it in. So what it's going to do, let's cut to the chase, is consumer representatives simply can't run complaints with that £250 fee up front, because it would burn through your cash flow. You issue 1,000 complaints, it costs you £250,000, and then you've got to wait to see how they fare, and then 6 months you've got to see what you get back. Well, that would strangle any business. No,
Yeah, 100%. No one's got that cash flow.
Exactly. Just sat there waiting. But that's only for 1,000 complaints.
Yeah.
How many? What were the figures from?
31.7 million.
99% of them have got.
Correct.
Yeah. So
had a commission paid.
Exactly. But 1,000 would burn through £250,000 cash flow. So that means that consumer representatives cannot function as a business.
Yeah.
You would turn clients and say, I can't do this. I haven't got the money. The consumer isn't going to do it themselves, because if they did, well, guess what's going to happen with the lenders? They're going to instruct solicitors. Why? Well, they've got lots of profit from mis-selling products over the years. They'll just farm it out to firm solicitors. The consumer will get a 12-page letter back saying, no. And the consumer will be dissuaded from bringing a complaint. I think, it's complete David and Goliath.
Yeah.
So it removes that level playing field that's currently in place with no win, no fee agreements, whereby, and the reason why I was able to take Mr. Johnson's case, the no win, no fee agreement element to it, and then not having to pay levies up front, means you're able to run the case, and you have parity, you have HD law, and then you have on the other side Eversheds, and it's matched, and there's a level playing field, and that's why you can have a case proceed all the way to the Court of Appeal and the Supreme Court. If we see the scenario that we've got with the FCA rules on a complaint level, that's gone. That's completely gone. There's no way, in my opinion, a complaint can be brought post the 1st of April that's got any chance of success, either by the consumer themselves or by that firm running complaints on a consistent basis, because they will run out of money within the first month. Once they've issued 1,000 complaints, it's like, well, we have to wait now.
Yeah.
So they know this, and I just don't understand how on earth it's been allowed to happen, because it's just basically saying to the lenders, this is brilliant.
Well, I think you said a couple of interesting things that I just want to go back to, is that people seem to forget that the likes of Martin Lewis and the likes of everyone else saying, you can just send a complaint yourself.
Yeah.
You've had 3 Lord Justices look at this so far in the Court of Appeal. You're going to have 5 Lords look at it in the Supreme Court.
Yeah.
This is anything but. If it was super simple, it would have been decided in the counter court.
Exactly.
Literally. It would never have had to appeal. You would never have lost it. You'd never have had to appeal to the...
We would shut our firms because everyone's doing it themselves.
There's
fine.
no skill set needed.
Exactly.
So, I think that's one thing that people forget, that if this was as simple as sending a complaint, well, why is it having to go all the way to the Supreme Court and have 2 interventions? And 2, the issue I've had with the FOS is that if you pay for something, especially something for £250 up front, the FOS is setting a dangerous precedent there for a level of service that you would expect for a paid service. With the FOS at the minute, it's obviously free. So if it takes 6 months, if it takes 12 months, as we know it does, if not longer, you go, well,
I didn't pay for it.
I've not paid for it.
Oh, well, I mean,
you know, it's like this, it's the same thing with Ryanair. You know, people who bitch and moan about Ryanair. Well, you paid 17 quid
exactly
for a flight.
Yeah, screw your head on.
So screw your head on. You know, if you've not got the leg room, if you've got to pay for your bag, then don't pay 17 quid. Fly British Airways and pay 500 quid or whatever it is. So just going back to the FOS, it's a free service at the minute. If they're going to charge $250 for a claim, a complaint to be upheld, what is the level of service that the consumers can expect and the professional firms that represent the consumers expect? Because it's got to be slick. It's got to be slick. And like you say, the next point that I've got issue with is that the access to justice element is one that you just discussed about paying 250 quid from a cash flow perspective. It completely destroys
any business.
It would destroy any business. You know, even the biggest law firms. If you've got £250,000 to put to the side for just 1,000 complaints, which is not a lot of complaints, by the way, considering how you can procure
38 million potential.
Correct. Yeah. So you £250,000 for every 1,000 that you upload. But from a quantum perspective, how you assess that client's potential redress, knowing that if you win, they're still going to hold back 75 quid of that fee, and you're only going to get the percentage of fee under your DBA. So then that means that the threshold for clients who do qualify for a complaint goes even higher, because you've got to make it work from a financial perspective, commercial perspective for the business to make it viable. So not only are you going to have businesses that just go, well, I'm not going to escalate this to the FOS at the detriment of my client because I don't have the cash to physically pay that fee. But two, everyone who does have merit to go to FOS, where you can afford to escalate them to the FOS and pay the £250 fee, you're then going to set some form of hierarchy scoring system within your own business to go, well, I'm only going to push the most quantum heavy lucrative cases to the FOS because I've got to take a bath on 75 quid before I even disperse the cash back to the client. So it just from a client detriment perspective, it is just disgusting in terms of there is nothing good out of this that will come out of this that will benefit the client. It is all going to directly benefit the lender and how much they pay out.
Lenders must be skipping down the street with this news because they'll just game the system. They'll just reject the complaint from when you write your letter of complaint.
Well, that's what I wanted to ask you. So with everything that we just discussed there, is the weaponisation of FOS by the lenders a real thing? They've
done it for them. I think FOS have absolutely given the lenders an open goal. It's too irresistible. You just reject every complaint and say, go on, I know you're not going to pay the £250 fee. What are you going to do? What will happen then? The courts will be inundated. Because guess what? When you issue a claim and you're successful, you get your issue fee back in full. And your issue fees on the small claims track are less than £250. They range from £50, £80, £115, off the top of my head. The court system is a better system.
If you're going to escalate,
put aside that you get a better standard of justice from the court because they look at things forensically, it's consideration of the evidence, etc. You're getting, in terms of disbursements, a better return. You get 100% of your disbursements back. You get your issue fee, your hearing fee, you get those back. In FOS, like you say, they keep £75. I don't think you're going to... The answer to your question is, and I think it was phrased in that way, you're not going to get any material improvement to the FOS service for your £250. This is, in my opinion, a naked deterrent to say, stop bringing complaints. I think there's been real muddying of the reputation of complainant firms and law firms who bring these complaints by the banks. And it's like FOS have lent into it and gone, yes, these are the baddie in the story and they need to be stamped out. And what we're going to do is make it absolutely economically unfeasible for these claims to be brought. So the net result is no complaints are brought. Or you're going to get, say FOS on average handled, picking a number out there, 10,000 complaints a month. I think it'll go down to they'll get a few hundred, maybe 100.
Well, what's mad about this is we spoke about this week is that there was that whole case of Unison, about it was Unison versus the Lord Chancellor in the Supreme Court, 2017, if anyone wants to check it out. And that was basically, excuse me, all about employment tribunal fees. Yeah. And they have got the track record of how the introduction of these fees doesn't work. They actually have published in all of the documentation that there was a 66 to 70% reduction in claims submitted to them because of the fees. Obviously, what we've just discussed. Yeah. But they literally came out and said that it disproportionately affected lower value claims, making them economically unviable, which is what we just said. But there's a whole precedent here of how this doesn't work. How it literally achieves what we've just discussed for the banks. It's a massive win for the banks. Yeah. But from a client perspective, it didn't work. It affected the most vulnerable clients. And then they ultimately abolished it. Yeah. So, is this another case of the regulators, the FOS, etc., where they've not learned the lessons from past days of PPI, plevin, employment tribunal fees, and they're just introducing something without the left hand talking to the right hand? Possibly.
I think they know what they're doing. I don't think this is the case of them not learning. I think they know exactly what they're doing. And I think they're leaning into the lenders. I mean, the FOS and the FCA are funded through the levies they impose on lenders and statutory fees, but it is the fees that they charge lenders, and it feels like the paymaster is the tail's wagging the dog. And they've, I imagine, lobbied hard for this imposition of the fee. They've created a real distorted picture of what claimant firms are about, including mine, including yours. And they've won insofar as they are going to introduce these fees. Now, I really hope someone judicially reviews it. And to touch on the Unison case, it does get overturned because I cannot see how, from a access to justice point of view, it can be allowed to continue. But it's going to shift everything towards the courts, and the courts are going to be inundated because a blind man on a galloping horse would realise it's better if I go through the courts. It's cheaper. I get a better standard of justice. There's more control because we've got the civil procedure rules. And my understanding, and I'm happy to be corrected if I'm wrong, isn't the FOS meant to alleviate the courts?
Literally took the words out of my mouth.
The Ombudsman's meant to be this kind of halfway house. Mm-hmm. You don't have to... Court's the last resort. We always got taught at university. The lenders don't engage in ADR. They don't settle. Yeah. So it's court or... it's trial or bust. Yeah. Isn't the Ombudsman meant to be this kind of halfway house, this stop-off before the last resort where you can resolve things amicably? They've just priced everyone out the market. And
you just hit the nail on the head. Yeah. The main rebuttal in the county courts that we've come across is that... Do you want some more water? Mm-hmm. Yeah. There's the main rebuttal that we've ever come across is that we have always had from the deputy district judges and the district judges that we shouldn't be taking up their time in the courts with these matters, and they're not a court matter because it's just volume claims. But the FOS thing, like you just quite rightly said, it just makes you go straight in and go, well, why would I not issue on this? Because it's gonna be heard probably a lot faster, but it's also going to be heard a lot more in depth by a sort of subject matter expert, and it won't be by 4 invigilators who are tasked with overseeing 10, 20,000 cases. And one other point I just wanted to say was that how long from introducing the fees and physically paying the fees will it take FOS to scale up? If their whole argument is that we're going to make the FOS self-sufficient, it's going to earn its own money, you don't just start taking millions of pounds in fees on Monday and have the resource to handle all of those claims by Friday. So that's going to be a 12-month, 2-year recruitment process, then the training, then the learning. You know, so at what point are you going to genuinely get the result that they're arguing in the sort of Treasury Select Committee interviews and so on? And then the whole recent sort of controversy, which makes me get even more conspiracy theorist, is that Abby Thomas, the CEO of the FOS, just magically disappeared. She's gone. There's been some altercation within the FOS. The CEO is out. The Baroness Manzor, who's the chairwoman of the FOS, she's out the door she's announced that she's retiring in August.
Yeah.
So I suppose the point I'm trying to make is that if you live and breathe FOS, and you just as much as you live and breathe financial mis-selling, consumer claims, if something didn't look right, you would immediately sit there and go, no, that's a stupid idea. That's going to cause all of these problems. They're very, very obvious, and we've just discussed them for the last 10 minutes. How is the FOS, whose sole job is to be an impartial adjudicator for these financial conflicts, literally financial ones, nothing else? How do they sit there and go, this £250 fee is within everyone's best interest?
Well, they can't do it with a straight face. I mean, what they're creating is a mis-selling charter, because if you're a lender, it almost makes mis-selling seem worthwhile, because you think, well, what's the worst that can happen?
Yeah.
They can't bring a complaint. Let them take the chances through the court. They're going to have to find a niche law firm who specialise in it. Hello, Sentinel, HC Law, here we are. And they'll just game the system. So what's the incentive, or the deterrent, I should say, rather, for a lender to stop mis-selling? Because they know, well, the avenue of recourse is priced out. It's too expensive. So if we keep mis-selling, what's the worst that can happen? I mean, you hit the nail on the head. They're called the Financial Conduct Authority. So let's take it right back to basics. Whose conduct are they monitoring? Lenders. They're the ones who deal in finance. What are lenders? Lenders are powerful institutions who can set terms, who can set ways in which they sell products to the consumer. The consumer doesn't have an option, doesn't have bargaining power, can't say to a lender, change that clause, I don't like that, can you take that out? As two businesses would. They would bat terms back and forth. So they need to be monitored, and they need to be incentivised to act fairly. They're not, because what are we on now? A second mass scandal in the last 20 years. They're obviously, it's the Wild West out there. They're doing what they want. They're not fearful of the Financial Conduct Authority. And you think, by the time the FCA catch up with any mis-selling we're doing, we'll have made a couple of billion.
Yeah.
We'll have to pay a little bit back, take a haircut on it, the odd couple of million. But bottom line, we're up on the deal. Who loses out? The consumer.
Yeah.
Why are they bothered about them? They'll just keep mis-selling to them, which is, disgusting. So there's no deterrent. It almost makes mis-selling
part of your business
seem worthwhile, because what's the downside? I can't see a downside here. Okay, we might take some reputational damage, but a couple of adverts, a couple of horses galloping down the beach.
Well, the lack of choice in the industry as well. Like, all right, where else are you going to go for your mortgage?
Financial Conduct Authority, they're so far behind. I said it before, they're so reactive. Oh, something's been missold. Oh, okay. They're just getting led a merry dance.
Yeah.
And as I say, even when a complaint is brought, at the moment, it's the lender who pays the levy on the complaint being upheld.
Yeah, it's like 650 quid.
So in effect, the lenders are the paymasters of the FCA. So the tail's wagging the dog. They're saying, well, can you not do,
Yeah.
They must have lobbied hard.
Also, show me the evidence you're paying that.
Yeah. Well,
Show me that evidence. I want to see that.
I'm sure it is. I'm sure it is.
Have they got a 180-day credit account or something?
Who knows? So it just stinks. Really does. It's breathtaking. I mean, as I say, I put those responses in. I think I've sent them to you before. I'm happy to publish them.
Have they published the consultation results yet? I've not seen anything.
No, I kind of lost interest because I was, funnily enough, it's funny how all these days tie in. So the 1st of April is the start of the Johnson case.
Yeah.
The 1st of April is the date when the fees
go live
for consumer representatives to bring complaints. And the date I sent my response to the FCA about the FOS fees was the day of Johnson.
No way.
In the Court of Appeal, the 4th of July. But as I say, I was typing out my answers. It just felt like a fait accompli. This is coming in.
Yeah.
And obviously it fell on deaf ears. I went straight in the bin. I don't think they considered anything I put. But it's just unbelievable. I'm almost struggling to believe that it will actually happen. It's that bad. It's that abhorrent to access to justice. I'm like, I actually can't believe they're going to try and bring this in. I mean, there's going to be no complaints being brought, so the FCA and the FOS going to start laying staff off.
Yeah.
Because they're not going to be busy. Because who are they going to handle complaints off? There's not going to be consumer representatives en masse. They might be able to do the odd one, like you say, the big ticket cases. And then you're left with consumers who are going to bring complaints themselves. You might get a few erudite people who've got, maybe retired and have the time and the inclination to do a complaint.
And all the documentation.
But your average consumer, I'm a solicitor, I would delegate that to somebody else.
Yeah.
If it, my brother's a solicitor, he doesn't work in financial selling. He wouldn't do his own complaint. He would give it to me or give it to a firm. So go and do that, I'll pay you the 25% or whatever. It's nothing wrong with two private individuals saying, will you do that for me? I'll pay you a fee. Why the FOS are looking into that, going, we're not happy about that, we're going to level a fee on top of that, is insane.
Yeah,
it's absolutely insane. And this is the other point, sorry,
no, go on.
I'm really on one now, I've got the gum shield in. I think the thrust of what the FCA's, or what sparked it, was we want to cut out spurious complaints, vexatious. I'm not being funny, but these car finance complaints, they're likely to have the right agreement number. There's going to be car registration. As you say, there's a high probability of commissions being paid. That will be a rock solid, bona fide complaint. It's not made up. It's not, what you might get with an unaffordable lending complaint. These, like PPI, the policy existed, the lender existed, the commission was paid, it was paid to the underwriter, the client had paid money towards the PPI policy. It was an absolute stonewall complaint. You couldn't go, well, you've made that up. Like, it happens in, to give you an example, road traffic accidents. Some of the claims might be made up. You might get two people and they create a crash and they one sues the other and all that. That's fraud. You can't get that with financial mis-selling with these types of complaints because the thing exists. The agreement existed. You can't make up an agreement. You can't make up the sale of the car. You can't make the car up. You can't make the dealers' names up.
No.
Acme, dealers, they existed. So everything's in place. So the idea that these complaints are going to be vexatious and waste FOS's time is utter nonsense.
Yeah.
But they want to bring it in. It's like, we're not listening to that. We're still going to bring it in. You're like, you do realise you were going to strangle. You said a roadblock. They are blowing the road up. That road does not exist. You've got to go to court. And court's the better route now, because if I pay an £80 issue fee on the small claims track and my financial mis-selling claim is successful, I get that £80 back. I don't get £75 kept and here's your fiver, see you later. It's the full whatever I pay because that's right.
Yeah.
And what really bugs me is who started this? Who started this scandal? Lenders, greedy lenders in cahoots with brokers. Why aren't they paying the full fee? If you get a successful complaint, you in plain language, you want to say, well, you started it. They wouldn't be bringing a complaint if it wasn't for you. You can pay it back. They don't even have to pay the consumer representatives' fees at complaint level on the small claims track. They get away with that. They only have to pay what the consumer gets as redress. They started it. Why isn't all the fees, as it is now, levied on them?
Yeah.
This is what I don't understand. This is why, from a pure fairness point of view, you explain to somebody in a pub, in any context, they go, that sounds wrong. And you'd be like, yeah, it's insane, isn't it? That's what I feel. It's baffling. It goes beyond legal, if you like. It's just inherently unfair. Someone's caused a problem. You've gone to them and said, you've done this to me. You've kept me out of money. You established that you were entitled to that money back. You get it back. But then you've got your representative who's done all the hard work for you, as you instructed them to do, has to pay extra money. Why?
Well, you've got to look at the whole situation with the claims at the moment. I mean, for the last 2 or 3 years, the lenders have been paying very, very, very expensive barristers to attend
small
lots
of profits, haven't they?
Yeah, they've got loads of money, but they argued proportionality. they've been sending £3,000, £5,000 per day barristers down to the county court in Devon, you know, for a full day of travel and everything like that to hear a small claims matter. You know, and that's what they're used to paying. So paying 650 quid up front for every single complaint they ever got, that's a discount.
The way I see it, if FOS is saying we charge the lender 650 and we need to charge you 250, just charge them 900.
Yeah, just charge them the full.
Guess what? They've got loads of money from mis-selling stuff, but you're charging the person who's out of pocket and their representative, their agent. So you want their agent to stump up the cash to bring it. It's so unfair.
Well, it's like you say, the it's not just that, the access to it. It's what's the FOS going to do? What's the FCA going to do when they uphold all of these complaints in the consumer's favour and they realise that they're seeing the documentation provided by the professional firm, they're seeing the documentation being provided by the lender. It'll be very, very clear that this could have been solved between the two parties and never involved the FOS. So what are the regulator and the FOS going to do to penalise the weaponisation of the system as it will happen? What are they going to do to the lenders to say, hang on a minute, this is like the 100th claim we've seen now. This could have been easily settled. You know,
Nothing, no. They'll do nothing. They'll absolutely do nothing. They'll do nothing. It didn't happen in PPI. It was they're reactionary. They react. They don't go out there and say, right, we are not having a third mis-selling scandal. This stops now. They just kind of, okay, get on with it.
It'll go on for decades.
Yeah.
That will go on for decades.
And it's the consumer who suffers the most. They are the victims of the mis-selling scandal. If consumers were not mis-sold, you and I wouldn't exist as law firms. It's as simple as that. And that seems to be forgotten. They started it.
Yeah.
They caused this whole issue. And we're just dealing with the fallout, and we're representing clients.
Yeah. Well, the one of the mad things that I saw last week, I think it was an article knocking around. Obviously the Treasury got knocked back on the intervention, but then they came out and said that if this is allowed to go ahead from a redress perspective, it will mean less profits for the bank, which means that it will impact the taxable profits for the Treasury. And that was the whole argument, I kid you not, that, the banks aren't going to make as much money, so we can't charge them tax on the profits.
Yeah.
But I was like, well, that is the most stupid argument, because if you're trying to stop this, but you're also trying to stop consumer firms, professional firms from doing this, then we're not going to make the profit. So no one's going to make the profit. Yeah. They're still going to pay out direct to the claimant, but you're not going to be able to tax them.
Yeah.
You know, we're going to do a significantly more. The corporation tax bill will be massive. So... It just feels like the whole thing has not been thought out properly. You're throwing these arguments against the wall. It's like in the consumer's favour. It's going to do this. It's going to do that. It's like, well, it's not going to achieve any of those. And just when you said about the dates before, I was wondering whether Abby Thomas, the CEO, she's departed now, so her name's not sort of dragged through the mud as like, how can the FOS ever do this to consumers, as we've just discussed. But with the Baroness, the chairwoman, she's departing in August. Is that sort of a hat tip towards when we could potentially see the judgment coming down, and she doesn't want any part of it because she knows it's bad as well?
No, I don't think that's
switched on.
Switched on. No, I think that's just coincidence. I mean, we can only speculate as to why Abby Thomas, is that her name?
Yeah, Abby Thomas. Yeah.
She left. Obviously, you can join the dots on that. Just going back to your tax point, like, what's going to happen? Let's take the view that there is mass redress and it gets put back in the pockets of the consumers. They're going to spend that money and pay VAT. They're going to buy other goods. The government's going to make tax from that money going back into the economy.
Go out and spend it. Yeah, I think it's they call it like the economic multiplier effect. Yeah. And for every £1 put in someone's pocket, it's like depending on how far down the line you are, it's like 1.5 or 1.8 times the value of that pound. Yeah. Because of, obviously, you go out, you buy something, it's got VAT on it. Yeah. That company that sold you that then pays profits on that, corporation tax. But then what usually happens is you go out and buy heavily dutied goods, fuel, cigarettes, alcohol, obviously.
Might get a new TV or something.
Yeah, stuff that has got big margins in it for the government. And that's the maddest thing. We actually wrote to the incoming government at the time. I thought I was a bit more optimistic on what they were going to do in regards to consumers, but we did a full calculation, and it was based off a £23 billion redress scheme, not what it is today, like that's about 40 billion. And we worked it out with just fag packet maths, just to say that this is worth, honestly, billions and billions and billions to the economy from just a pure tax perspective and the way that money goes. But one of the things, just to sort of round off the whole FOS conversation, is that in that Treasury Select Committee meeting that happened between the FOS and the Treasury Select Committee 2-3 weeks ago, they said the FOS actually came out and said that they've got about 166,000 complaints backed up for car finance complaints. Yeah. So how long is it going to get them? What are they going to do with the backlog, let alone the stuff that's going to come through, which will probably be that per week?
Yeah, that's probably even more pertinent to that timeline you're saying, like first things first.
Yeah,
we'll have to deal with the backlog.
Yeah, and is that going to be a one-size-fits-all? Because 166,000... I mean, has the FOS even got the infrastructure to deal with that as of now? Because from my understanding,
I doubt it. No, I doubt it. It could, I mean, what are we talking here? 2029? It goes on and on and on.
Yeah.
It's the issue is it's the same with the courts, is that there's no real incentive or pressure put on lenders to settle these claims either pre-FOS or pre-litigation. Mm-hmm. So they can game the system. They can go, it's a flat rejection. Mm-hmm. You can say, well, I've got this Court of Appeal decision, or, they'll find a way to split hairs or find a loophole and say, no, we're defending it. They're entitled to do that. But the problem is that there's not any consequence for that conduct. There isn't. They can flatly reject something. There's no pushback, particularly on the small claims track. They can reject offer after offer, run it to a final hearing, lose, and they'll say, well, we're entitled to defend it. Yeah, it's so one-sided in terms of the big businesses, the situation. So what you end up doing is having to go to the FOS, to court, to get redress, and then you are faced with these massive delays, the lack of resources. There's just simply not enough FOS, what would you call them, case handlers to deal with it. There's not enough judges. The county court system is only so big. And let's have it right, they should be dealing with more important issues than financial mis-selling a lot of the time. And I completely agree with that. But the problem is, what was the consumer to do when they've been told or advised, look, you've been missold, you're entitled to your money back that you've paid through the finance. It's their money. But bad news is you're going to have to run the gauntlet of FOS with its fees coming in on the 1st of April, or the court system where you are going to have to attend trial because your lender will game the system. They will instruct external barristers who will defend it all the way to trial. They'll instruct a very experienced barrister, probably from the city. Yeah. So that's the problem. You are forcing motorway traffic into country lanes, and it just causes delays.
Well, I think just going back to what you said about the judicial review, I think, if anything, if there was any sort of call to arms, it'd be now for CMCs, because they've got the most to lose out of this opportunity. They're the ones. They're the ones who are aggressively onboarding clients. They're the one running all the social media ads and so on. But if this FOS system does get weaponized, you can't escalate to the court. You can't go and issue on this. So what are you going to do? Are you going to allow your cash flow to be that massively impacted, or are you just going to throw the towel in? And I think that this is my genuine opinion, is like, why there's this massive call in the industry for collaboration, but the CMCs don't seem to be thinking that far ahead. And I think it's them that have got the most to lose. Whereas Sentinel, I know HD Law is the same, is we're geared up for volume litigation. We know how to do these claims. We've been doing them for the last 2 or 3 years. If we did have to go down the litigious route, we can spin that route up very quickly and quite easily. Yeah. The only limitation being, like you quite rightly said, is judicial availability. Yeah. Some of the courts, Liverpool, Manchester, etc., are a lot more equipped to handle volume.
The city ones,
but other ones are not. But ultimately, that's the game of the claim process of issuing. You issue your claim, and see you in 18 months type thing. But it gets heard. it gets the proper disclosure, it gets the adequate time, and you cover all of your costs as you're currently doing as a business now. I just can't understand the whole lack of from the claims management scenario when they've got a lot to lose.
You feel like saying, look, on the 1st of April, the nuclear bomb's about to go off.
Yeah. And what's your plan B?
Yeah, well, you are going to be blowing out the water. Mm-hmm. This isn't a roadblock where you kind of go, okay, let's find it. It will obliterate it, because I doubt there is a CMC out there that can sustain thousands of claims. Sorry, forgive me, thousands of complaints on a long-term basis, because, as you say, for the first 1,000, that's a quarter of $1 million. Mm-hmm. Your second 1,000, you know, 4,000, it's £1 million
what's your out?
that you have held in FOS fees.
Yeah.
What? And how long are the FOS going to take? You got to join the queue. Congratulations, you're 166,001 and 2.
Correct.
You're right behind.
Yeah.
So how long can you allow £1 million, £2 million to be held, not used, and strangle your cash flow?
Yeah.
I doubt there's a CMC out there that
no
can
way.
Or would want to. Even if they did, they'd think that's a really bad business model.
That was literally took the words out of my mouth. Like, but from a business model perspective, that risk is like, okay, you are solely dependent on the FOS now, and you don't know when you're going to get that result. You don't know whether they're going to hear it. Obviously, you've got to pay for that luxury for them to hear it. You know, at least from a law firm's perspective, you can go, well, I'm going to issue a complaint. Yeah. If I don't like the
time scale I can give you. Yeah.
If I don't like the way the sort of weather's looking, okay, no worries, let's issue the claim.
Yeah.
And you know, you can almost jot that time frame down on the back of your calendar as to when, you know, you'll have to file your witness statement, and when you've got to like pay your issue fee, pay your hearing fee.
You can almost do it by courts.
Yeah, literally.
The courts who've got more resources tend to be in the city.
But also, you've got the luxury of having the barristers who. There's quite a lot of barristers out there that are very familiar with car finance claims now, who do a lot of the heavy lifting for you once you packaged it correctly. You put it on the barristers, there you go, boom, it's over to you now. So it is really interesting, I think, from...
There needs to be a judicial review. The CMCs really do need to, like you say, have a collegiate...
well thought out approach.
Get together.
And not sit on the sidelines and do nothing and all squabble over who's putting a fiver in.
Yeah, and really consider a judicial review, because if that judicial review is successful, it's going to save them millions of pounds.
Millions.
But I'm astonished that it's been brought in. It's disgusting, and it leaves such a bad taste in the mouth, because it's just inherently unfair. It's not what the FOS should be about. It's a free service for consumers. But if a consumer wants to delegate that task to a specialist at no extra cost to anybody else, only the consumer, why does FOS need to get involved and add levies to the agent? It's insane. As I say, I'm in disbelief that it's actually going to come in about a month's time. Yeah, it's like we're through the looking glass once that happens.
Well, the thing as well, what there's another element to this is like the wider industry. Obviously, they're not living and breathing car finance claims every single day like we are, but there's a lot of talk at the minute regarding discretionary commissions. Yeah, and everyone seems to be so fixated on the fact that it was originally discretionary commissions that were banned by the FCA, but there's no reference to that in any of the meaningful reference in terms of like the FOS, what they're going to see, what they're going to uphold, the whole element with Johnson and so on. And it's no longer about this discretionary element that we're all talking about. We're talking about the fact that there was an unfair relationship, that someone did not disclose that commissions would be paid, whether that was discretionary or fixed or whatever, advanced commissions, volume bonuses and so on. We're talking about the full returning via compensation of commission, and that will be up for the FOS or the FCA to decide, and it won't be going, oh well, you've submitted a complaint, just show me where the discretionary commission element is. Oh, this is fixed, this is not, this is how we segment the complaints, and this is only what you can complain about. We're talking I just want you to sort of confirm or make sure I've got it absolutely right, but we're talking about any and all commissions here.
Yeah, it's the focus of discretionary charge agreements, where the interest rate is linked to the level of commission, for those who don't know, is putting the cart before the horse. The focus is on the commission model per se. Once you
have not disclosed.
Yeah, that you haven't disclosed. Once, I'll use the pun, but once you lift the bonnet up on what kind of commission model is it, well, then it's just a question of how unfair it is. If it's a fixed one, it's very unfair. If it's a DCA one, it's well unfair. It's unfair with bells on. That's all it really is.
Yeah.
But the focus has been on, it's looking through the wrong end of the telescope.
Correct.
Is to perhaps put it another way. And the focus needs to be on commission models per se, not just let's just.
It's only discretionary that's being up for debate, which is not the case.
It's a bit of a misnomer, the whole focus or lack of focus as it can also be on DCA models. They're not the real evil. They're bad, but that's like the icing on the cake. The focus should be the non-disclosure of a commission model.
Yeah.
Because everything at that moment, everything changed. The consumer was then placed in the dark. They weren't aware of the panel of lenders. They weren't aware that they could get perhaps a better deal from a different lender. That was the opportunity was ripped away from them. And then when you get into, well, how bad is it? The DCA model just means it's even worse than if it's a fixed model.
Yeah.
But it's been a typically, as I say, looking through the wrong end of the telescope approach by so many parts of the industry, particularly the FOS. I mean, what I was experiencing prior to Johnson, before everything went on hold, was the FOS would typically reject fixed commission model
and
agreements.
The courts,
yeah, because there was like, well, what's wrong with the commission? Well, it's not disclosed, that's the problem. And it's breached various duties and we're entitled to these remedies. But hopefully the Supreme Court will, answer the question for everything. And from that, we'll get a bit more of a sensible, coherent analysis across the industry, including the FOS, as to what constitutes a missed sale, where it's a car finance agreement, not this cherry picking of let's go for the low hanging fruit. DCA model, obvious. It's like, well, yeah, but let's look a little bit more laterally at the whole model itself, and the principles behind it, and then that's what triggers the thing being unfair. Yeah, they've just gone for the obvious.
Well, I think the perception of fixed commissions by the wider industry that haven't litigated on claims and got the level of disclosure that we've collectively got is that it was, Mr. Smith on the shop floor earned 50 quid for selling the Mercedes. Yeah. What's so bad about that? And, in principle, correct. Yeah. No one's begrudging the salesperson.
There's nothing wrong with the commission.
Correct.
But you've got to disclose them.
But you've got to disclose it. But in actual fact, the fixed commissions, we've seen it a number of times with Santander, actually outweighed the discretionary commissions. And
you just remodel it.
Yeah. It's just what they're calling it. And I think there's a lot of people out there spreading misinformation because quite literally they do not know that they're repeating what they've heard in the pub from their other CMC mate or law firm mate. And this whole, I keep saying it as like the FCA chucked the industry a bone or a distraction to go,
bit of toffee.
Yeah, we've banned DCA, the IC, whatever you want to call it.
Can everyone just calm down now?
Yeah, we banned it. And in actual fact, it was just, everyone's focused on that. Everyone's saying, okay, it's only DCA, it's only DCA. It's absolutely ridiculous. That couldn't be further from the truth. It's the whole, if you to use the lender's language, it says we may pay a commission. It doesn't say we may pay a DCA commission. It doesn't say we may pay a fixed commission.
Exactly.
We may pay a commission.
And doesn't then they say, and if we do pay a commission, that commission will be linked to the interest rate that you will pay?
No. So this whole fixation, I genuinely think was like a false flag to go, you go all focus over there.
There's a biscuit,
The rest of the industry, 50% of the industry is not being allocated for.
Exactly. The other thing as well, 2 points I want to pick up with you. The first one is, if they were to ban DCA models, say we were a dealer and a lender, you'd say, well, they've banned these models we were using for your agreements now. And what we used to do, if we could get the interest rate at 5%, we charge £800 commission. But if we got them up to 12%, we charge at £2,000. And you go, right. Okay, so what we're going to do now, we'll just have a fixed commission of £2,000. great. That's it. That's how you get around. You just go, okay, well, we'll just same wine, different bottles.
Yeah.
But the other thing as well, and it's the thing that's not picked up on as well, is the notion of advanced commissions or volume bonus. Like you say, there are many ways commissions were paid. There's the commission to Mr. Smith on the
dealer floor.
Showroom floor. Yeah, he gets 50 quid. Then there's the commission on the agreement itself between the bank and the lender. Sorry, the bank and the dealer. But there's also the here's $1 million up front.
Yeah.
Have an advanced commission. If you sell 10,000 of our agreements in the first 6 months, we'll give you an advanced or a volume bonus commission. So it's commission on commission on commissions, and this is the other thing that the industry, from our side of the industry, perhaps aren't appreciating, and perhaps because we're down and dirty.
Yeah, every day
is that it's not just the commission that the dealer gets from the lender per transaction. There's other macro, or you know, it was the same in PPI when what you would have is you would have the lender taking an 80% commission. So for every £1 that the consumer would pay towards the PPI, they give 20 pence to the insurer and say, right, I'm keeping that 80 pence. Then there was profit share as well. There was this wider,
oh, really?
Like, wow, what's that? Yeah, it was like it's exactly the same, well, similar in my opinion to a volume bonus. It was almost like a sweetener or an upfront.
Yeah.
So a volume bonus is where you get paid like a global fat commission for selling X amount of cars in a fixed period of time. Well, then you need to go and go, right, you got a volume bonus of £1 million or whatever, and then it's spread across all these cars. What does that volume bonus equate to my client? Because it mightn't just be a £2,000 commission. With the volume bonus, it might be another 727 pence and £27.14. So the commission really, because of the transaction, is it's a lot, could be a lot higher. This is the other thing which makes mass redress a little bit tricky, because you also have to take into account any additional commissions. It's like, how far does the branch, how much of a branch is it from the commission does it go off into? It as you say, it doesn't stop short of the guy who's selling the car, because you straight away go, that's not the commission we're talking about. That's an employee incentive.
Yeah.
Your next one is, obviously, what is it in relation to this transaction? Well, it was a fixed fee of £2,000. Well, right, that's the most obvious one. Was there a volume bonus? Okay. Was this car part of the volume bonus scheme? Yeah. Well, it must have a pro rata.
Correct. It does.
Percentage.
It does.
Well, can we add that on as well, please? Because had you not sold this car, the volume bonus might not have been met, and it's all triggered. So it's, they were doing kickbacks on kickbacks.
Yeah, it was.
And this is something that's probably not been brought to the public's attention, really, because we're discovering it. Because guess what? The whole industry was secret. And as you know yourself, you're kind of pioneering the pre-action disclosure application, a lot of things come back redacted.
Yep.
They must be running out of Sharpie pens. Because
well, yeah, I was going to say, well, that's the thing, and this is why, like at the start, when I said, kind of feel a bit battle tired now, because the whole discretionary interest element, everyone's aware, yeah, that's bad. This is where the industry is getting the valuations from, and that's what Moody's are saying and stuff like that. But I mean, we've got, like you said, we've done a lot of pre-action disclosure applications, and we've really, really found a lot of naughty things in there, mainly in between the agreement between the lender and the broker. And I think it was in the Court of Appeal when they said, you could never have had upheld a fiduciary duty, never have had a disinterested duty, because they were saying they were going out to a panel of lenders, but they weren't, because they were getting preferential terms from FirstRand Bank, for example, where they got the biggest commission. So they were always going to give Kevin's car finance deal to FirstRand Bank because they got the most commissions for it. They were never going to go out and consult the wider market. But I mean, this is what's infuriated me about the entire industry for a while, especially now, is that even though it's getting more and more public awareness, and we're talking about, like, it's literally in the Supreme Court in 5 weeks' time, that no one's really sat down and gone, besides obviously what you're doing in the Supreme Court, no one's ever rang Kevin Durkin up and gone, Kevin, you seem to be a subject matter expert in car finance mis-selling. Is what we're getting from the banks real? Like, is that what you're seeing in disclosure, or are they spinning us a load of lines? From the FCA's perspective or the FOS's perspective, or whether the judiciary at a specific court was gone, I'm seeing a lot of these. Let me speak to someone who genuinely knows what they're doing, and not necessarily a barrister who just sees the best cases and just gets instructed on a client-by-client basis. It still can see, considering how advanced we are in the industry now, from it's going to the Supreme Court, and then there's going to be the most binding precedent you could ever ask for at some point this year. It feels like no one in any position of unbiased power from a regulator perspective or an ombudsman perspective, or even, I know we're on with the Treasury Select Committee in an hour, but no one's gone, Kevin, what's your take on this? It boils my blood to an extent, because I'll read an example out. We've got a client who took out a Land Rover, retired guy, took out his Land Rover about 2 years ago. His commission on this, he took out £81,000 worth of, I've done a podcast on this, £81,000 worth of finance, right? Yeah. £16,049 paid as a commission. Wow. So 19.69% of the total amount of finance was paid as a commission, right? 61% of the cost of the finance, so the interest, 61% of it was commission, right? But it was split into three different things, just going back to what was originally said. There was the DIC element, which was £9,781. There was the fixed commission, which was paid to the head office, paid as a percentage of the amount of finance that you just said. Yeah. That was £4,279. And then you've got what's called an outcome bonus, which is £1,988 as an outcome bonus. And the outcome bonus wasn't a case of like, oh yeah, you've done really well this quarter, or you've got loads of positive Google reviews. It was simple, and I've read the terms. Simple as, did the clients cancel within the first 3 months? No. Okay, there's your good customer outcome bonus. And it was called literally a good customer outcome bonus. Not because they've done anything that's benefited the customer. No. Not because they've done something really, really good. They've got a lot of good customer feedback. Satisfactory is up. Did they cancel within 3 months? Yeah. Meaning we've had to... Did we get away with it? Did we get away with it? Okay, cool. Yeah. So you've got that. So you're looking at £16,049 of commission, overall commission on a deal. Yeah. And, the industry and the FOS and the regulator still banding around this idea that DIC, discretionary interest models, whatever you want to call them, is like, oh, that's it, that's so bad. Yeah. You've got literally nearly £5,000. Well, you've got, including the outcome bonus, you've got just over £6,000 paid as alternative commissions on top of the discretionary. Yeah. And I think that is, just going back to what my original point was, this is what really, really annoys me, because the banks are pleading poverty, the government's pleading poverty on behalf of the banks. They're saying it's going to crash the economy. They're going to say, oh, what's the problem with earning a commission? I'm sorry, he's earning a commission and he's taking the piss. Yeah. And this is on a Land Rover, probably one of the most common cars on the road. Yeah. It was by Santander, which has got, I think it's the second largest car finance lender in the UK right now, and it was via a massive, well-known car dealership that I won't name, but you'll have definitely know the name if I said it. Yeah. It's like, well, Santander and a massive car dealership who's part of a dealership network that are all over the UK. That's one client on an £81,000 loan for a Land Rover. So is that on every Land Rover in the same price bracket? Because it's still Santander. It's still the same dealership group. Yeah. It's not an obscure one. No. So that's just... balance of probabilities. Exactly. Probably say it is. So I just go, well, how can anyone sit here and go, oh yeah, we're only focused on this part of the market when this is massive? Well, I don't think they want to upset lenders. I think that's why it's not getting attention. It's because... they don't want to upset big business. They don't. It's all very nothing to see here. Shh, come on. But was that the same in PPI though? Yeah, it was. For years, it was seen as a ridiculous or a spurious claim. What you the notion was, it was very like, well, but you had you've had insurance, so that's a good thing. It's like, well, I didn't want it, and you told me. Typically, it used to be you told me I had to have it in order to get the credit card. That's not right. Yeah, but you've had peace of mind. It was all this
pat on the head. You know, can you not? Don't. Look, we have to make money, and sometimes we'll sell things you don't want, but shut up.
And it was said that only about a third of all PPI premiums were ever claimed back, was it?
Exactly. And it wasn't until Plevin came out and really just dug into it, and like what you're driving at is got into it and go, what is actually going on here? It's not just the sale of the thing itself. It's the product, and the fact that you're not telling them. This is, like you say, they take the piss. They can't help themselves, so they go, what commission should we take? 10%.
Yeah, as much as we can get away with.
Let's go 94%, as they did in Potter.
Yeah.
94%. 90, like...
Wow, was that what it was?
94%, it was 94%, yeah. I had another case, same time as Potter, which I did in Carlisle on the small claims track. And it would have been the lead case had Potter not gone before a recorder. And it was the same. It was exactly the same level of commission as in Potter. And I said in submissions, just to make the point, it was 94 pence in the pound. The judge must have said that about 5 times in his judgments. And they knew he couldn't quite believe it. 94 pence in every pound was being kept by Canada Square as commission. I mean, what are you doing?
That is ridiculous.
And it's the same principle with the example you've just shown there. They can't help themselves. They're just greedy. And I think they think we will probably get away with it. And what's the worst that can happen? We have to pay some back. No one's going to prison. We're not going to get shut down. We'll still be trading.
Yeah, didn't one person get sacked or something? Just was it? Oh, was that? No, that was the financial crisis.
Yeah, it was one person. Yeah, Lee Harvey Oswald. Yeah,
one person that caused the global financial crisis.
Yeah,
got sacked.
Yeah, they had their patsy. It's, you do wonder, and you speculate, and you can go through conspiracy theories, but you do think it almost makes mis-selling seem worthwhile because there's no deterrent.
No.
And who's there to protect the consumer besides the likes of us? Because the FCA are dragging their feet. No one's policing it. They were allowed to do it. There's the horse bolted, and then there's the entire Grand National set of horses have left.
Yeah.
And it's like, well, it's a mess now. And then we're there to pick up the pieces on behalf of consumers, and yet we're kind of painted as some pesky upstarts. It's like, look, I wouldn't exist if you didn't keep me selling. Simple as that. I'd do something else. I'd do a different area of law, but I'm in this area, and guess what? There's a lot to go on because it's so widespread. It's insane. I think you're right. I think it's probably atypical of a transaction with Santander and that particular car, or across all car dealers. But it takes the likes of you doing your applications and then spreading the word. Otherwise, we'd never know. This entire mis-sale is secret. The clues in the word, it's kept under wraps. It's kept hidden. Why? Because they don't want people to know. Why? Because people would complain. What's wrong with that? Well, we'd have to hand out redress, and that's bad for business. We've made lots of profit. Forget how we've made it. It's money in our account. We're not giving you it back. Come hell or high water, we will fight tooth and nail. Court of Appeal decision, well, we want to put that to one side because that affects our bank balance. You know, the shares tanked following that Court of Appeal decision, and they're fighting tooth and nail to preserve it. So it's not hard to understand if you just get into the mentality of a bank. It's just someone who's greedy, earned their money by cutting corners, been found out, doesn't want to give it back, doesn't go, actually, do you know what, Court of Appeal, we've considered your decision, you're right. We shouldn't have done that. We've made so much money doing that. We'll hand it back. It's never going to happen. They're just going to be greedy.
Well, I think that's it. I think you've hit the nail on the head there. It's like, I think there's a lot of people out there that haven't been red pilled yet, though, as well.
Yeah.
Who think, well, no, that's surely not. You know, there's still, shockingly, I mean, especially after COVID, there's still a lot of people who trust the institutions, trust the government, think everyone's going to do fair by them. No one would rip them off. And unfortunately, like, you couldn't be more wrong to the point where, you know, this financial mis-selling scandal that we're looking at in terms of car finance claims.
The second one,
Yeah, the second one. Like you say, that it's the second one.
And the first one was to do with undisclosed commissions. So it's like, didn't you...
But we're not talking about a different generation. We're talking like, you know, a decade ago.
Yeah.
You know, they were paying out billions of pounds in compensation. But at the same time as they were paying that out, they knew this was going on.
Yeah, which makes you think.
So is it like, oh well, it doesn't matter. We're paying out on PPI and plevin, but we're absolutely having it off with car finance claims.
We'll make 10 million make 10 billion, pay $1 billion back.
Correct.
9 billion.
Sounds like good business to me.
Good business plan.
Yeah, unbelievable.
Do it.
And that's I think that is the issue. You know, just going on the whole public awareness of this, journalism, the regulators from one sense of the argument, but definitely the consumers, and more importantly, the county court judges, which I think a lot of people don't realise that you can just be a very good solicitor and go and become a judge.
Yeah, I have a lot of sympathy for the judges because of the way in which the banks press it to trial. They raise all as much issues. They want to create a headache, and it's hard for any judge who's not familiar in this area to take on a lot of information. You know, because the court lists are busy. And I say it again: there's more important things judges should be dealing with than car finance. These cases should be settling before they go to FOS, before they go to court. There should be a kind of, right, okay, fair enough. The law's behind you. We'll do you a deal. But lenders game the system. And it's tough for a district judge or a deputy district judge to pick up a car finance case and wrap their head around it in a timely fashion. These hearings are listed for three hours on the small claims track. It's not really enough. You need a full day. You really need fast track cases.
Like 300-page bundles.
Exactly. And then the lenders will instruct a barrister, and he'll do his job thoroughly, or she'll do his a job thoroughly, and there'll be what's called an authorities bundle, which will have all the case law, and it'll be a real deep dive into car finance. And fingers crossed, if the Supreme Court follow on from the Court of Appeal decision, that should be flattened, and it remains to be seen whether the lenders still want to game the system by pressing as many cases as they can to the small claims track. But it is tough, and we've got to work within the rules and the confines. And at the moment, with the FOS basically pricing themselves out the market, for want of a better phrase, it looks like the court route is going to be the only route.
Yeah.
So hopefully the Supreme Court decision goes our way and creates the law. Either way, it's going to create the law that will bind everyone, but really sets down in a logical, coherent fashion what the correct approach to these claims are. I'm sure they will. They did it in Potter, and that really, that limitation argument went by the wayside. For an example, really did. Prior to Potter, a lot of banks would argue they didn't deliberately conceal the commission. They'd argue, well, the rules didn't say. Potter just drove through that and said, look, the Consumer Credit Act indicated you should have disclosed the commissions to act fairly. You didn't. And that argument went. And then I'd go to court and it would be 9 times out of 10, it wouldn't be pursued. Hopefully, if the Supreme Court decision goes the way of the consumer, it'll flatten a lot of things. But unfortunately, even if you've got a superb decision from the Supreme Court, you can't go to FOS if you want to run a business and if you want to hold down a full-time job. But if you're retired and you've got a penchant for legal matters and you want to do it yourself, then...
Be my guest.
Yeah, be my guest, but you probably...
Get you on the podcast, tell you war stories in about 2 years' time.
Give them a job.
But just before we sort of wrap everything up, obviously the Supreme Court has its ways of dealing with things, and everything has to be done the same as any court appearance does. You've got your time frames. This needs to be filed on this date. You receive defence on this date.
Yeah.
Where are we kind of up to? I mean, we're recording this on the 28th of February. Like, what current stage are we at?
So we're at the point now, in terms of a typical Supreme Court case, where the written cases are in the process of being exchanged. And then it's just gearing up for the hearing. As I say, we're really in the home straight now. The written case is similar to a skeleton argument in county court level, but it basically sets out in written form both each party's reasons for why their argument should win. And it's filed with the Supreme Court in advance, so the judges have an idea of what the arguments that are going to be made. And then after that, it's the preparation of the bundles and all the case law. And then it's all systems go on the 1st of April.
Brilliant. And you reckon it's going to be busy?
Yeah, I imagine it'll be quite a chocker courtroom.
I was going to say, I've never been to the Supreme Court. Like, how does that work in terms of a, bums on seats perspective? Because I've watched the videos on YouTube, but is it massive? Like, is there plenty of seating or what?
I've had the Potter case, and I observed on a case of Smith. It's quite a large room, as you can see from the video, and the Potter case didn't attract that much media attention, so it wasn't that it wasn't that busy. This has done and will. What you tend to find is the public can come and go. Typically, on a Supreme Court case, it can be a tourist attraction.
Well, so mid conversation, the Lords can be speaking.
You see people walking in like they've done a day shopping in London.
No way.
Like Union Jack carrier bag,
and they don't interrupt.
Oh no! It's the whole process of open justice is that any member of the public can sit in and listen to how justice is being done, which is quite right. But you would find while you're taking note, you'd see just people mill in and out. They'd be quiet. The usher would say, "Can you please keep it down? You can't come in making a racket.
Can't bring in your boots meal deal.
You can't eat it or anything like that. You have to be respectful to the court." This one is, I think, going to be packed to the rafters because there's so much attention from the legal world, as you were, but there's wider implications. There's a lot of media coverage. So yeah, I imagine this will be
well attended.
It'll be oversubscribed, I think. But it's online as well. You go to the Supreme Court website.
Yeah, do they
upload
be a
live feed?
Will it be a live feed?
Yeah, it's a live feed.
Because do they upload that every day, or is it just live?
It's in real time, and then it's, I think, the Court of Appeal was up via YouTube. Which
that's why I watched the Court of Appeal one on YouTube.
The Supreme Court has its own
YouTube channel.
Function. Yeah, well, it might be, but it has its own kind of hosting platform.
Oh, it's actually on the website.
It's on the website.
Yeah, so people can watch it on the website.
So you watch your live stream, and then I think it gets saved as a link, and then you can go back to it. And watch it again.
No, you're right.
So anyone can watch it. I think anywhere in the world, I imagine, if as long as it's confined to the UK.
Yeah, and I presume that'll be just stay on there every single day, so people can watch it.
Yeah, watch it.
So just sorry, I keep coming up with more and more questions, but on the Supreme Court, will that start at 9, finish at 5? Like, what's a running day for the Supreme Court there? How long do we get for lunch?
It's 10:30, I think.
10:30 start.
10:30 till 1. Hour for lunch, and then 2 till 4, maybe half 4.
Oh, right, okay. So you're not going to have numb bums and stuff like that?
No. And I remember in a Court of Appeal case where it was in the middle of summer and the aircon wasn't working.
No.
So, they had to have the windows open, and they were flexible with the hours.
Yeah.
But general run of time can be 10:30 till 1, and then 2 till 4, half 4. They can be a little bit of flexible, but they're not too flexible.
I can imagine.
They have strict time frame because they'll have to do so much reading. People may not realise that, but there's so much reading for them to do because they come in and they are on it. The judges, they know, they're so experienced, and it's amazing to watch. It's spectacular.
I thought you could submit these complaints just via Martin Lewis's tool and do it yourself.
Yeah.
Can't be that complex.
Yeah, exactly. And I think I remember on the Potter case, they actually stood us down because they had to deal with the Rwandan plane taking off.
Yeah.
So on that occasion, I think they sat a little bit longer because they chopped into our hearing. The judges literally went out into another room, dealt with the Rwandan application because it was an emergency one, and then came back in. And you could watch online.
That's wild.
Yeah.
No way I'm going to find that. I'm going to try and include that in the podcast.
Yeah. And
that's on the Potter case?
The Potter case, yeah. So that's 15th of June 2022, roughly, I think. And they can sit a little bit longer, but it's usually 10:30, 1, 2, 4 / half 4, depending on how the day goes. It goes back to the point why you're a little bit reticent to interventions. I mean, the clue's kind of in the title. If someone's intervening, you're like, sounds like you're obstructing me or slowing me down, you're intervening. So there's a balance to be struck between the Supreme Court, and I think they've definitely struck up the Supreme Court having interveners they think will add something different and not duplicate what.
Yeah, well, that's what it said, isn't it?
Yeah.
They can't duplicate their
Exactly.
submissions.
Otherwise, what's the point?
What's the point?
It's
Yeah,
just
we're just
an
heard
echo
this.
chamber.
Yeah.
But it not cutting into this, the time frame. It's 10. So they've got half an hour, and they will be like, you've got a minute left. It is really like, like Live 8. You've got your set, and you've got to come off when
your X Factor audition. Well, no, that's been. I mean, we've been going for an hour and 45 minutes now. So, but I mean, anything else that you wanted to cover?
No, not really. I've been allowed to kind of get on my soapbox about the false fees.
It's been good. It's been interesting, to be fair, because like we said at the start, there's everything we discussed on the last podcast. It's been and gone, and the result has come from whatever we were speculating for. So we're 5 weeks away from the Supreme Court. Obviously, it won't be the last time we're hearing from you.
Don't forget, we'll never know more than is what we know right now. We are at the zenith of what we could possibly know about car finance, and so much has happened. Like you say, between our last discussion, it feels so far. Like you say, the decision was handed out less than 6 months ago, and it feels like a decade ago, really.
Yeah, well, that's what I think. Going back to like the whole battle tide thing, we were just getting over with the October 25th of it being handed down, and then all of a sudden it's like, well, we're 6 weeks away from the Supreme Court. Yeah. I just can't believe how fast it's going. But
I know I wasn't grey when
but
handed down.
But no, anyone who's sort of listening wants to get in touch with Kevin, he's on LinkedIn, Kevin Durkin, HD Law. I don't think you're on any other platforms or anything. But
no, not really. Keep it simple.
Keep it simple. But brilliant, mate. Well, we'll speak in London, I imagine, next time.
Yeah, looking forward to it.
Cheers, mate.
Cheers.